disclaimers and fine print. We see that a lot. But when you get to read it, it is very important information which you need to have to make an informed decision. So quite a few businesses rely on disclaimers and disclosures or even clarifications, but they have this buried in fine print as an excuse. Sometimes it becomes an excuse for engaging in misleading or deceptive conduct. But today I want to say to you is that fine print is illegal under the Consumer Protection Act. So this information, like I said, it is important for you making a decision. You need to put it in a print that is legible and even close to the prominent display that you are advertising. So you're advertising cars, and before we would have had quite a few businesses advertising cars, and what would be the catch for persons would be the monthly payment. So you will have $6.99 monthly. But then at the bottom of that ad, you will see special conditions apply. And the special conditions were always in this fine print that really, it was like, you didn't really worry to read it because it was quite difficult. That was an issue under the legislation, and we addressed that per the requirements of the legislation. And we're going to speak to that a little bit more. But I just want to say to you, if you're going to be advertising any good, any product, any service, and the information is such of importance, it must be in clear and intelligible language so that I can make a decision whether to buy it or not. So advertisers must pay particular care and in relation to the products and the services that they're going to advertise. And we know some businesses might tell you, but we have an advertising company or doing our ads. But even those companies are not exempt from the implications of the legislation because they too need to know the requirements of the legislation as they do their business. So all the promoters, like I said again, promoters, advertisers, all the quotations that you give persons, all the statements that you give them, must be clear, must be sufficient information, and it must be accurate so that persons can make an informed decision. But then you might ask me, but if I don't get this information and I go ahead and I purchase, then what happens? And at that, like I said, it will be a case-by-case basis. And you had to come to the commission. We will look at that situation by a case-by-case basis, because then we will need to have documentation if you were given documentation, and to go through that documentation to see what the documentation said. Even like I said before, even the statements made by the representative of the company. And so they can't opt out of it because we've said to businesses, you need to put things in place to ensure that your staff is trained, that the products that you're selling, they know what they're talking about. Because if I or any other person comes into the business and they tell me something, I have a right to rely on that information to make a decision. So it should not be an excuse where, oh, this person is new or this person only came on for a specific period. If you're going to be doing that, we're not saying not to hire, but yet you will be held accountable for the information that person, that employee gives to the consumer. So you need to train, you need to put protocols in place to ensure that these things do not happen. Even if it means that that person will call somebody senior to address the issue. Whatever you do in your course of business, you need to ensure that the information that is given is correct. Because when we look after investigation, we recognize, hey, you breached the legislation. There are penalties that are attached, and we will talk about at the end of it. But there are penalties attached to the legislation, and we are at the stage now, we've been around for some time, we are at the stage now of enforcement, of taking enforcement action against any business who contravenes the legislation for which we enforce.